Mena-Watch, der unabhängige Nahost-Think Tank.
A very warm welcome to this book presentation of Florian Markl's book, The Other War. I'd like to introduce the author, Florian Markl. Did you know? The head of Mena-Watch. My name is Stefan Kanopul. I'm a journalist and author, and I've been asked to moderate this book presentation. Thank you for the invitation. Mr. Markl, before we get started, you've written this book that talks about how international law is being exploited and misused against Israel. I think we need to talk about international law first before we get to the content of the book. We've been witnessing in recent weeks and months, almost on an hourly basis, how international law is, in principle, misused or differently applied, where we hold an alternate view or a different perspective on how international law is utilized or interpreted. We have the Russian war of aggression against Ukraine, and now America is a new player on the scene, which was previously notable regarding international law, but is currently in the spotlight with Venezuela. Could you explain what international law is? So how is international law defined? Is it interpreted differently by everyone, or can we agree?
Well, you see, a very fitting definition, in my opinion, was once provided by the American political scientist Hans Morgenthau in one of his works. It's not quoted verbatim in the book, but the gist of it is, international law is a law that most states adhere to most of the time. That pretty much sums up what we're dealing with. Well, it's not just Russia, or for that matter the United States, that, when it really comes down to it, tend to disregard international law when they're pursuing their own interests. The Europeans can do exactly the same. Just remember the Kosovo War and the Bosnian War. And those were all interventions that were not covered by international law. Instead, ad hoc coalitions were formed, and they simply did whatever they wanted to do. Besides that, the fact that UN resolutions are ignored is a completely everyday occurrence. Every country in the world does it, some more, some less. Austria does it too, by the way. There is a UN General Assembly resolution which explicitly calls for the immediate repeal of all sanctions imposed against Russia, stating unequivocally that they are illegal. I wouldn't know of any indication that Austria would be prepared to follow that resolution. International law was always, quality-wise, a very different kind of law than domestic law. And the crucial difference is quite simple. There is no sovereign on the international stage. There is simply no one, so to speak, no higher authority that could assume the role of referee. Theoretically, it exists with the Security Council, but that's a very theoretical possibility. And so, what we're dealing with is that all states, when they pursue their interests, are of course usually happy to comply with international law when it happens to align, but if not, then it's not a major obstacle either. I don't think that Putin or anyone else would be deterred from doing something just because international law somewhere claims they shouldn't. However, for such individuals that is never a valid argument. Of course, there is theoretically a higher authority, that is the United Nations Security Council. However, it has fundamentally been, from its very inception, an institution that has always been completely paralyzed by the veto power of the 5 permanent member states. Thus, the supreme body for the maintenance of international peace and security, as stipulated in the UN Charter, has essentially failed to prevent a single war since 1945.
Although one must of course say that international law doesn't just cover war and peace. In that sense, but rather encompasses many other points. International law is certainly vital and respected.
But truly, the most controversial aspect of international law is indeed what's called humanitarian international law, or issues concerning war and peace. But that really is a relatively minor part of the entire body of international law, so to speak, that has become quite convoluted. The vast majority of international legal regulations remain largely unaffected by such breaches, or are indeed consistently observed and upheld. Why? Yes, because states enter into treaties based on their own interests, you see. And there, everyone has an interest in adhering to them mutually. There are actually only a very few specific topics that are so profoundly contentious, or where legal regulations are so flagrantly disregarded or not, where they are simply not respected at all.
Now, your book addresses misuse of international law in its title. Could you briefly explain the Gaza situation? What exactly is this misuse? What's your accusation? That you have elaborated on in this book, in contrast to numerous other viewpoints that present this war in an entirely contrary light?
Well, what we've been observing, not just since October 7th, but especially since then, October 2023, is something that is widely referred to as lawfare in the English language. Thus, a connection between law, in other words, jurisprudence, and warfare. So, in other words, it's the instrumentalization of legal provisions, specifically international law, in the ongoing conflict against Israel. So, what is the misuse that's taking place? Well, there are different levels or different ways the misuse occurs. So, on the one hand, existing international legal regulations are being interpreted or construed in a manner that simply has no application anywhere else in the world, and this interpretation is specifically tailored for the case of Israel.
No issue.
Well, for example, immediately after the massacre of October 7th, on October 7th, Antonio Guterres, who is none other than the current Secretary General of the United Nations, made a statement regarding the massacre. In this statement, he mentioned, among other things, Israel's decades-long occupation of the Gaza Strip, drawing attention to a perspective that has been a significant point of contention for many years. Now, anyone who has paid any attention over the last 20 years knows that Israel completely withdrew from the Gaza Strip in 2005. There wasn't a single until October 7th. There wasn't a single Israeli soldier in the Gaza Strip. There wasn't a single Israeli in the Gaza Strip unless one had been abducted by Hamas. Nevertheless, institutions such as the United Nations, Amnesty International, and Human Rights Watch, among others, consistently asserted that the Gaza Strip was occupied territory. What constitutes an occupied territory is a topic in international law, specifically humanitarian international law, where much is open, but in this case, occupation is defined quite clearly. In the Hague Conventions and in one of the Geneva Conventions. And that unequivocally clarifies, without the presence of so-called boots on the ground, that is, without the occupying power's soldiers physically present to enforce any measures, and without an alternative administrative body serving the interests of the occupying power, a state of occupation simply cannot exist. Since 2005, none of that existed anymore. Israel had completely withdrawn. Nevertheless, they write, or rather they claim that it's a case of continued occupation. Nowhere else in the entire world is such a specific concept of occupation utilized. In fact, entirely new terms were even specifically introduced to describe it. They talk about asymptomatic occupation, functional occupation, and various other concepts, who knows what else. Many auxiliary constructs tried to hide the simple fact no Gaza Strip occupation existed post-2005. So that's one method, these completely arbitrary reinterpretations or redefinitions of things. And then there are other cases where arguments were simply made based on an alleged international law that doesn't even exist in that form. For instance, there were reports from Human Rights Watch and Amnesty International regarding the allegedly prohibited use of white phosphorus, a particular weapon. It's not forbidden by international law. That was simply an invention by these organizations. And so, many such examples can be cited, and indeed, I list a number of them in the book, demonstrating how international law is reinterpreted, or in some cases, completely rewritten anew. And all of it, of course, always with one goal in mind, always with the aim of putting Israel on blast.
But isn't there a majority in international law who say that what Israel is doing in Gaza, etc., is indeed a breach of international law? Are they all wrong?
Well, first of all, especially in the US, there are, of course, many who argue differently. There are also some in the German-speaking world in Europe who interpret this differently. But you really actually have to discuss it always topic by topic. Currently, there's a new publication, for example, a book by a German international legal scholar who frequently delves into Israel-related matters. And what he's writing there simply doesn't hold any water. Yeah? So, for example, he's writing there about the Israeli attacks on Iranian nuclear facilities, and he claims they were illegal. This is because there's an article in a supplemental protocol to the Geneva Conventions that clearly states attacks on nuclear power plants are prohibited. That is absolutely correct, however. Israel did not actually attack a nuclear power plant. There wasn't a single one. The exact wording in this protocol is facilities for power generation. None of these nuclear facilities that Israel attacked had anything to do with power generation. They were either processing plants and so on and so forth. Either he doesn't know that, or he knows it very well and is deliberately saying something that is, at the very least, highly misleading by claiming an action was illegal when it simply didn't happen that way. You truly have to discuss this case by case, every single instance. There are some points. And one has to clearly state that naturally in international law, there's always a very broad scope for interpretation. and that, of course, is invariably dependent on political positions. And there are certainly some international lawyers who are simply anti-Israel in their views, and their expectations are shaped accordingly.
Come from, and that something is politicized. One term that has consistently come up again and again in recent months is the accusation leveled against Israel stating its actions have been disproportionate. Perhaps we can discuss this term, disproportionate. What does it mean, or how is it viewed? Perhaps you can explain it.
That's another one of those questions where it really depends on who you ask. If you've been following the media or significant portions of the media over the past 2 or 2.5 years, then disproportionality essentially means something along the lines of, there are X number of deaths on the Palestinian side in the Gaza Strip. There are far fewer deaths on the Israeli side, therefore it's disproportionate, therefore it's considered criminal, illegal, or something similar. This is a type of disproportionality that bears no relation whatsoever to the definition within international law. And that's what's remarkable, especially about this accusation. An international law term is used, namely proportionality, or in this case disproportionality. But what is being alleged there has absolutely nothing to do with what the matter is truly about.
A quick follow-up question. Is this term, or are these terms, proportionality and disproportionality, part of criminal law? And if so, in what form? How is it being used?
Yes. So there is a very clear definition of the term proportionality, and it clearly states that it always refers to individual specific operations, never the entire conflict itself. It's never about the entirety of the war in itself. Instead, in the context of an ongoing armed conflict, the definition is as follows. It always boils down to the question of what targets are permissible for bombing or attack. And there's a crucial distinction that civilian targets must never be the subject of attack. So, inherently, civilian targets aren't legitimate objectives. Only military targets are permissible for attack. However, there is also a significant restriction, which states that if civilian targets are utilized by one warring party for military objectives, for instance, if Hamas strategically places rockets in schools, stockpiles them in mosques, or confines hostages within hospitals, all of which have indeed occurred, then Hamas thereby transforms these very objects and facilities into legitimate military targets. And that is where the question of proportionality comes into play then. Proportionality refers to a situation where an operation is planned and civilian casualties are expected. You know for a fact that civilians are present, and the principle of proportionality then comes into play. It's always about ensuring that the military objective, meaning that the harm, the damage that civilians suffer, the destruction that is wrought, the deaths that are to be mourned among the civilian population, that these are not in an absolutely disproportionate way. Be in proportion to the military purpose, to the military advantage. And that is a very broad formulation. You must first know exactly what the military purpose of a particular operation was, of a particular attack on a house. One must know exactly what information was available to those who carried it out. What could have been reasonably expected to happen there regarding civilians, for example? How many civilians are there? How many casualties could result, and so on? And even if civilians are present, it doesn't automatically mean the attack itself is disproportionate. It's always about this relationship between the military objective on one side and the civilian suffering caused on the other. That relationship must not be disproportionate. That's the definition. And so, a simple comparison of casualty numbers just doesn't get you anywhere because the numbers say nothing about how those casualties occurred, under what circumstances, or whether they were the result of legitimate military operations or not. All of that simply does not hold up when solely considering this concept of a mere juxtaposition of casualty figures.
But who then defines proportionality? That's a term that is interpreted and applied in vastly different ways. One person says it's disproportionate, another says, of course, it's proportionate. There's no control, there's no oversight body that can check or define proportionality.
Well, truthfully, the only one who can truly answer that question, at least initially, is the military commander who ordered a particular attack. He knows what information was at hand. He's aware of the specific target that was indeed attacked. He knows if the intended target was actually hit in the end, or if it was perhaps the wrong building, or maybe the intelligence was wrong. Anything can happen, and mistakes occur in every war, certainly in the Gaza war too. But ultimately he is the only one who, at first, has all the information necessary to even be able to answer that question. And ultimately, of course, it's the same situation here as we discussed at the beginning. There is no higher sovereign authority that can decide on the matter. Ultimately, there exist wildly divergent interpretations, and once more there are instances, for example, the reports from Amnesty International, where they contend with proportionality or disproportionality, yet the provided examples offer no substantiation whatsoever, for it's unequivocally clear that the organization, or Amnesty in this scenario, possesses not even remotely possessing the information that one would need to be able to make a truly serious assessment of the situation at all. So, a well-known example is that relatively early on in the Gaza war, residential buildings were targeted or residential buildings were struck. What did Amnesty do? Amnesty had some people it knew in the Gaza Strip because no one could enter from the outside anymore. Days after the attack on these residential buildings, it sent people there and said, "Go take a look around." They looked around, then reported back to the London headquarters. Well, we didn't see any Hamas. Therefore, there was no Hamas. Therefore, it was an illegal attack. Yeah, that's just not how it works, plain and simple. That has absolutely nothing to do with an international law assessment of a military operation. And the interesting thing is, this only ever comes from the media, from human rights organizations, from the United Nations, and so on and so forth. When you speak to military experts, be they strategists, trainers, or active or even former soldiers, they almost never, or very, very rarely, make such an accusation. They truly grasp the complexities of such situations. Thus, nearly all military experts one consults, their evaluation of Israel's conduct in the Gaza conflict starkly contrasts with the constant reports from Amnesty, the UN, and various media. This is because these individuals, unlike the others, comprehend the mechanics of war and grasp the complexities of warfare itself, and also of the regrettably cruel realities that normally accompany war.
And in this war, Israel is accused of genocide. By several human rights organizations. Amnesty International has already been mentioned, also by UN bodies, etc. Is that just another misinterpretation, in your professional opinion, of the situation, to cast this accusation? Or considering the sheer number of fatalities, it's quite clear that are in the Gaza Strip, is that a partially justified action? Or is it perhaps the exact opposite?
Well, regarding the number of casualties, I believe it's important to preface this discussion with a few points before we can truly delve into the question. So, first off, we do not possess any reliable figures regarding the fatalities, that's absolutely certain. What everyone refers to are always the data from the Ministry of Health in the Gaza Strip, and the Ministry of Health in the Gaza Strip is Hamas and no one else. This means the numbers you're getting come directly from one of the two warring parties, and in this case from the Islamist terrorist organizations. There are several analyses of the numbers that have been published that show the great extent to which they were manipulated, the great extent to which numbers were simply falsified, and so on. However, the main thing is that the number by itself doesn't mean much, does it? So, if the current number, I think, from early February, Hamas claims, I believe, a total of 70,000 dead, what they never add is how many of those were their own people, meaning how many of them were Hamas fighters or fighters from Palestinian Islamic Jihad and so on. Because only then, if we had an approximate understanding of the ratio between combatants who were hit and were definitely legitimate targets and civilians. It is only when one has a somewhat clear understanding of this particular ratio that an initial supposition can be made about the events that transpired here. And the credible studies I'm aware of, those that have examined the casualty counts, consistently conclude that the ratio of civilian to combatant deaths in the Gaza conflict is remarkably low, smaller than in any other conflict of its kind. And in this particular context, comparable refers to warfare in an urban area, a largely city-based area, where the population density is naturally high and where there will inevitably be more casualties. I just wanted to preface with that. Now about the question of genocide. That's another one of those things. Genocide is defined relatively clearly in international law. There is the the so-called Genocide Convention, which was adopted by the United Nations in the late 1940s, you see. And it's unequivocally clear there too. A mere number of victims doesn't automatically make something a genocide. Thus, the sheer number of victims alone doesn't automatically qualify it as a genocide. Rather, there is a very precise definition stating that a genocide is only committed when actions are directed against members of a particular group, whether it's a national, religious or racial group as it was referred to at the time and so forth, when they when operations or actions are undertaken against them with the express intent to utterly eradicate that specific group from existence. That's the crucial point. It's about specific proof of specific intent to, so to speak, exterminate this group. And that's precisely where Amnesty International consistently fails. And in all honesty, they know this themselves, which is why they simply rewrite the definition, or at the very least, demand that it be done. So, they state quite explicitly and know precisely that the bar to prove this intention of genocide is incredibly high and has been consistently set at such a level by the relevant courts over recent decades, which is why there are only a very few cases of genocide in existence. And that is indeed correct. It is, if you will, the worst crime one can possibly imagine. There have always been very, very, very clear and very, very strict criteria, and Amnesty knows perfectly well that what Israel did does not meet them. So what do? They write, yes, well, we believe the court's case law has been far too narrow. It needs to be seen more broadly. So what they're actually demanding is a loosening of the criteria, knowing full well they can't fulfill them. In essence, they're calling for an altered definition of international law, or rather, of genocide, because they've already concluded that Israel is a genocidal state. And if the facts don't align, well, you simply have to change the definition.
Now, regarding amnesty, several states and other entities have currently filed a case alleging genocide with, among others, the International Court of Justice. What exactly is in this accusation? How or what legal basis underpins this case that has been filed?
Well, it's about. The legal basis is, of course, the Genocide Convention. That's why the International Court of Justice in The Hague is the responsible authority. It is the competent body for instances of Genocide Convention violations or alleged infringements thereof. So, how does this lawsuit actually operate? It operates in such a manner that the initial action by South Africa involves entirely disregarding the actual war that occurred. They proceed as if all events that transpired there were not a conflict against a terrorist organization, but instead a deliberate and focused assault on the civilian populace. Thus, if one delves into the South African lawsuit and the claims advanced within it, it's asserted that every single event unfolding in the Gaza Strip bore no connection whatsoever to Hamas. It's barely mentioned in the entire complaint. The Hamas tunnels aren't mentioned, the hostages aren't mentioned, rockets aren't mentioned. The fact that an armed organization, tens of thousands strong, was waging war on Israel is de facto absent from this indictment. Instead, it only speaks of a systematic attack on the civilian population. Thus, a complete derealization of the war is taking place. And then, in step 2, comes the conclusion drawn from that, accompanied by a few false or out-of-context quotes from Israeli politicians, asserting that all of this unequivocally constitutes genocide and expresses a clear genocidal intent. According to all the legal experts who look at this, or let's say reputable jurists who look at this, it's completely impossible. In and of itself, it's completely impossible that a conviction will ever come out of this. And in this instance, other nations have indeed joined this lawsuit, including most notably Ireland. And the foreign minister at that time also quite openly stated it. He urged the court to alter its criteria. Why? He knew it wouldn't work. That's the core of it. And that's really the core of the genocide accusation that Amnesty International also made, or that a special commission has put forward. The approach is consistently the same, the actual war is completely disregarded, and everything that has transpired is reinterpreted as an allegedly intentional and systematic intention to exterminate the Palestinians.
But then the International Court of Justice found the accusations plausible. So how did that happen? By your interpretation, it should reject that.
Yes, exactly. That's the next joke about the whole thing. It didn't do that at all. So, the International Court of Justice imposed provisional measures, and in that context, the term implausiblis appeared. But if afterward it's consistently claimed that it considered the allegations plausible, then those individuals simply haven't read what the court actually decided. The term plausible emerged explicitly in the court's statement because, in the immediate aftermath of South Africa filing its lawsuit, the court's primary responsibility was to ascertain whether the allegations presented could genuinely constitute a valid case under the Genocide Convention, meriting further investigation and deliberation. That means the court looked at, what does South Africa claim Israel did to it? And afterwards they had to assess this. If all of that were indeed true, would this ultimately amount to a potential case of violating the Genocide Convention? And they deemed that plausible. What it did not do, and it explicitly wrote this in the declaration, it did not engage with the substance of the allegations, with the specific accusations at all. And the then President of the International Court of Justice consistently clarified this in later interviews. She unequivocally stated, no, the court did not declare the allegations plausible. Rather, it merely asserted, if these claims were proven true, a plausible case for the Genocide Convention might indeed emerge. This is an entirely different matter, which has been completely misconstrued in media discussions. And also, again, the very same actors like the UN, Amnesty and so forth, they're really making deliberate or unconscious misrepresentations. No court has spoken of a plausible genocide in that regard. Quite the opposite. There is still a second procedure, the International Criminal Court, which we might still get to discuss later on. But the prosecutor wanted that too, because over there, this particular accusation is known as extermination. He also wished to incorporate that into the indictment and additionally establish it as the foundation for the arrest warrant. And the judges of the criminal court explicitly denied this request. Instead, they very clearly stated that the material presented by the prosecutor in that particular case was insufficient to establish the accusation of extermination. This means the only court that has genuinely dealt with the substance of the issue so far has dismissed this allegation, stating, the supposed evidence brought forward is simply not sufficient.
If that's truly the case, then why did the International Criminal Court issue arrest warrants for Netanyahu and the Prime Minister? On what specific grounds were these issued?
That's a rather intriguing story, which is quite complex in its details, but I will try to condense it into a few main points.
So I can understand.
Yes. So, the first thing is, the question is, does the court even have jurisdiction? Because the International Criminal Court always acts as if it were responsible for the entire world and possessed universal jurisdiction, but that's simply not true. Instead, the Criminal Court is essentially an association or an organization that was established based on an interstate treaty, specifically the so-called Rome Statute of the International Criminal Court. This means it only has authority over those who have agreed to it. All states that accede to it and have ratified this statute are, so to speak, members of the International Criminal Court, and by doing so, they have also agreed that this court has jurisdiction over them. Israel, but also, besides these countries, Russia, India, China, the USA, and so on, simply haven't done that. They either haven't signed or haven't ratified this particular treaty. This means that they are not members of the criminal court. Consequently, the criminal court effectively possesses no jurisdiction whatsoever concerning cases within these nations. So, how then can the Gaza war case even be negotiated at all? Because the court, or rather the pretrial chamber of the court, simply declared itself to be competent. You see, they basically declared a fiction to be reality. You see, they claimed in 2021 that Palestine was already a sovereign state. And if crimes are committed by Israelis within the territory of this state, then they are supposedly very well competent to handle them, even if the Israelis themselves are not members. This remains controversial to this day. Several states were asked back when this jurisdiction was still under discussion. What do you say to that? What do you say to that? And many states, Germany and Austria among them, explicitly pushed back, clearly stating, Palestine is not a state, and so the criminal court cannot have jurisdiction over Palestine. The court decided differently and declared itself to be competent. That's a foundational basis. Thus, we are even able to conduct investigations or proceedings in this case. And then there's the other question about the substance of the case, which we've already partially discussed, because it's the same mechanism at play again. Things are being brought forward that are completely absurd. For instance, Israel is being accused of having blocked the Rafah border crossing for an excessively long time, deliberately obstructing aid, and thereby intentionally causing a famine. Well, the Rafah border crossing was for most of the time. We're talking about this. The application for these arrest warrants came in May 2024. Up until that point, the border crossing was under Egyptian control for most of the time. The Israelis had no control over that border crossing at all. Nevertheless, they are accused of having closed it for long periods, thereby making aid impossible. That is simply and plainly not true. And then there are other instances where it is alleged that Israel deliberately jeopardized the lives of Palestinians by obstructing or seizing their water and electricity lines. Israel didn't do that. Hamas did it during their October 7th attack. Israel repaired these lines and supplied water and electricity to the Gaza Strip again. Nevertheless, all of this is being interpreted as constituting a part of a crime against humanity. And it works just like the other things we've discussed before. Here too, there's a complete derealization of the war. The manner in which Hamas conducts its warfare, particularly through the massive deployment of human shields and other tactics, which are largely responsible for the high number of casualties, plays absolutely no role in this indictment or in what has been disclosed about it. And, well, it's the same story all over again. The reality of the situation is completely ignored, and it's boldly asserted that this was a systematic attack on the civilian population. The truly intriguing aspect, and this marks our third point, now delving into the domain of what could really be called politically significant gossip, is this. Why did he even decide to bring charges in the first place? Well, you need to know about Karim Khan, who is now the chief prosecutor, who has since stepped down, and who was in charge of this, initially, after assuming the position in 2021, I believe, didn't particularly distinguish himself in continuing the proceedings against Israel, which had already been ongoing for years due to other matters. And even after October 7th, he didn't show any particularly reactive activity in this direction. However, that began to shift somewhat during the springtime. He then announced his plans for a significant visit to Israel in May, where he would gather first-hand impressions, engage with Israeli representatives, including political and military figures, to form his own informed perspective. He also conveyed to the assisting Americans that this visit would exert a considerable influence on the subsequent trajectory of his ongoing inquiry into this matter. And then suddenly, from one day to the next, he cancelled this imminent visit to Israel. Simply called it off, and then a day later, he swiftly presented this application for an arrest warrant. And everyone was asking, what exactly just happened here? What truly happened only became clear in hindsight, or at least one can speculate about what actually occurred. In late April, it became known that a female employee, or rather, Khan became aware that a female staff member of the International Criminal Court had approached colleagues with statements reporting that she had been regularly sexually assaulted by Khan for some time, meaning she was being forced into non-consensual sex, intercourse, and so on and so forth. And Khan became aware of these internal investigations, which had been initiated at the International Criminal Court around late April or early May. And just like that, his stance abruptly shifted, leading him to quickly push through this request for an arrest warrant. Why? Because on the one hand, he wanted to secure a kind of immunity for himself at least. That's the prevailing speculation or theory. This was because numerous member states of the International Criminal Court had been persistently advocating for measures against Israel or its politicians for quite some time. And his calculation then might have been to say, okay, if I bring Benjamin Netanyahu and Gallant, that is, the Prime Minister and the Minister of Defense before the court, then they won't try to get rid of me now. Then they won't just cast me to the wolves, so to speak, but will instead stand by me. Secondly, he launched a campaign asserting that these are nothing but lies and fabrications propagated by Israel to harm the International Criminal Court. And third, he made a strong effort to exert massive pressure on the woman. He contacted the woman who made the accusations against him multiple times, and explicitly referencing the lawsuit against Israel, he attempted to silence her. He explicitly said, think of the victims, think of the case against Israel. You can't possibly want to do that, and so on. So even there, he essentially exploited the Israel case to exert pressure on the woman who had brought forward the allegations against him. And now, just to continue this briefly, a second woman has now published very similar allegations against Khan. That occurred quite some time ago. Back then, Khan was not the chief prosecutor as he is currently, or at least he wasn't until this whole affair came to light. However, the statements contain essentially the exact same accusations as those coming from the female employees of the criminal court. And that is simply one of the theories, or at least I think a perfectly plausible theory, as to why Khan suddenly changed his mind from one day to the next. He scrapped, my apologies, he cancelled an upcoming trip to Israel and swiftly proceeded with this application for an arrest warrant. However, it is important to mention the application for it is one thing, but the judges of the criminal court also had to approve it, meaning the responsible pretrial chamber that is entrusted with the case, which consists of 3 judges, had to agree to these charges or this application for arrest warrants. This means that while Khan ultimately pushed it forward and initiated the process, the arrest warrants were of course not issued by him, but by the judges of this pretrial chamber.
Exactly.
What remains about the sexual harassment? That's just gossip, speculation, or theories that can't be verified here. Well, I personally consider that to be somewhat over the top in some aspects, or an interpretation that stretches things quite a bit. But as you said, 3 judges had to approve it. The rest is, I think, really just gossip and speculation, which we can't really explain here whether it really happened that way and if that was the background. Now, another question. Netanyahu. The arrest warrant, would it have to be executed? Is it legally certain that if he enters Austria, Austria would say, yes, Mr. Netanyahu, you are now under arrest in Herzogenburg and must be extradited to The Hague. Is that legally binding?
Well, that brings us back to the question of who is responsible for what, or rather, the unresolved question of jurisdiction. Essentially, all states that have joined the Rome Statute, meaning those who are members of the International Criminal Court, have consequently given their consent to transfer jurisdiction over their citizens to the court, should the situation demand it. They have agreed to this. This means if an Austrian citizen were to come under investigation for some reason, and an arrest warrant were issued, Austria would be forced to extradite them. Definitely. There's one exception. If Austria itself had ongoing proceedings, the case in The Hague could be suspended, at least for a time. But in principle, if it concerned an Austrian citizen, Austria would extradite them. The real problem here begins with the fact that Israel isn't a member of the International Criminal Court. This means that even if the Criminal Court declares itself competent for Palestine, the non-existent Palestine, it is still not competent for the very much existing state of Israel. You see, Israel isn't a member of this court, and this court, well, it's pretty much like other associations, if I may say so somewhat casually, other clubs. Everyone who is a member can impose rules on themselves that they have to follow, but the rules can't just be applied to others, and they aren't valid for others who aren't members. And that's where the problem lies. Now, Austria says it is obligated because Austria is part of the International Criminal Court, as is Germany. France, for example, is also a member of the International Criminal Court, but it has argued quite differently, saying, well, yes, on the one hand, there's this need to cooperate with the court, but on the other hand, there are also legally binding rules under international law that apply. And among these regulations is the immunity granted to prominent state representatives, specifically presidents.
Good thing that doesn't happen to America and we have the pleasure.
Right, that's the other yes, anyway. In this particular instance, France had articulated its position by arguing that both Netanyahu and Gallant, serving as the Prime Minister and former Defense Minister respectively, were indeed covered by a case of immunity. And immunity is a universally binding principle of international law. And the International Criminal Court, as a more minor subsection, so to speak, cannot simply enforce its rules upon others. And as far as France is concerned, a conflict arises between the obligation to the International Criminal Court on one hand and the obligation to the general rules of international law on the other. That's why France, it didn't explicitly state it, but it certainly implied that in this specific situation, it would uphold the general rules of international law, meaning it would possibly not extradite Netanyahu. The German Bundestag has a research service. The German Bundestag also tasked this research service with investigating what the legal situation actually is. This research service of the German Bundestag reached the same conclusion. He published a comprehensive, multi-page expert opinion on the matter, which ultimately concludes that this is, quite simply, a situation where two distinct and conflicting legal positions clash head-on. This matter is not definitively settled in a legal sense. Germany has obligations towards the International Criminal Court, but there's also the political immunity granted to high-ranking state representatives. Essentially, the International Criminal Court cannot, so to speak, truly supersede that immunity. This means that the scientific service of the German Bundestag simply speaks of diametrically opposing and conflicting legal requirements that somehow need to be met. Their proposal was that indeed one could resolve this by referring it to the International Court of Justice and obtaining a legal aid. So-called yes, one could obtain a legal opinion. The only problem with that is it takes years for something like that to happen. And even if an advisory opinion from the International Court of Justice were ever issued, it still wouldn't genuinely hold legal validity. That's because, as the name itself suggests, it's nothing more than just an opinion. It is not legally binding in and of itself. So, fundamentally, political players, be it Germany, Austria, or anyone else, must decide between these conflicting legal norms. But a clear-cut obligation to arrest Netanyahu, as has often been claimed, doesn't exist in that form, or at least not with that clarity.
I have another question on international law. Israel's essentially fighting a terrorist organization. Can international law truly be applied in such a manner within a conflict, or rather during an armed struggle against an adversary? Does it even really apply here?
Yes. Well, there are different types of international law. Essentially, when discussing armed conflicts, a clear distinction is always made between what are referred to as state wars, that is, armed conflicts occurring directly between different nations. Those are quite well adjudicated legally, so to speak, or rather, there are very clear regulations established for such situations. Much less legally ordered, so to speak, are cases of wars or armed conflicts with non-state actors. Now we can debate what Hamas is for a long time. Hamas is, of course, a non-state actor. At the same time, it has had de facto sole control over the Gaza Strip since 2007. That means it's at least a sub or para or whatever other state actor, or a state-like actor for that matter. That's a question on which international law experts themselves hold differing positions. Most would consider this conflict, or even a war, to be a non-international armed conflict, precisely because Hamas does not represent a state. For many questions regarding the laws of war, specifically humanitarian international law, it doesn't significantly impact, as core norms apply to both conflict types. Immediately after October 7th, there were indeed voices arguing that there was absolutely no right to undertake military action. This was because, although the UN Charter includes the right to self-defense, Hamas is not a state, and therefore Israel lacked the right to proceed with action against it. That was, once again, another wonderfully interesting interpretation, at least regarding international law. Because there is indeed this Article 51 of the UN Charter, which speaks of the famous right to self-defense in the event of an armed attack. However, nowhere in that article does it state that the attack must originate from a state. That was simply superimposed on it later. It only speaks of an armed attack, against which there is a right to self-defense. And interestingly, the United Nations itself and also the UN Security Council have already recognized this right to self-defense against a terrorist group as correct and given. Right after October 7th, after September 11th, after the terrorist attacks in New York and Washington, the Security Council passed a resolution. It was clear that there would be a military resolution from the US afterward. And there, it was explicit. The US right to self-defense against armed aggression was explicitly referenced. And naturally, Al-Qaeda isn't a state organization, but a non-state terrorist one too. This means that the Security Council, in reality, already decided years ago, in this case, yes, there is a right to self-defense even against non-state actors.
One final question before we take yours. When reading your book, one comes to the realization, or at least believes they do, that different standards are often applied to Israel. How did you arrive at that conclusion, and why is that, or what's your explanation? And why do you believe you interpret this differently than most other organizations, or the UN, etc., or international law experts?
So for now, let's just put aside that question of why. Let's just hold off on that for a moment. Is that so, or is that not so? Well, you only have to look at what accusations are being leveled, and then ask yourself, are these accusations also being made against anyone else anywhere in the entire world? And you come to the conclusion, no, it just doesn't happen. For instance, this claim of an occupation without any soldiers present and so on, that's not applied anywhere else in the world. You can really go through this with quite a few examples. That means, and that's always the problem, a right is truly a right in that sense, only if it is universally applicable, so to speak. A law that applies to only a single entity but not to others, or is only enforced against one person but not others, is simply no longer a law. Instead, it becomes a question of political arbitrariness, or something akin to it. But in any case, the universally binding effect and obligation of the law are definitely lost when you're dealing with that. Why is that the case? Well, you have to look at the actors involved, those who are driving this. So, at the very forefront, you'll find the United Nations are taking a leading role. And regarding the United Nations, one simply must say that, since the late 1950s or early 1960s at the latest, it has unequivocally become the most intensely anti-Israel organization globally. Period. You can truly grasp this across the board, whether you examine the decisions made in the General Assembly, where literally dozens of resolutions against Israel are adopted each year, Meanwhile, other nations such as Saudi Arabia, North Korea, Iran, Russia, or China, and who knows. This list could go on forever. There are never any condemnations against them. In the last 20 years, there's been an average of about 20 condemnations of Israel. Why? Is Israel really the biggest criminal in the world, that all resolutions are directed only against it? Then there are the infamous sub-organizations like the UN Human Rights Council. It was founded in 2006 because its predecessor, the Commission on Human Rights, had become so discredited, not least on the issue of Israel, that Kofi Annan abolished it essentially as an act of self-preservation for the United Nations. And so, the Human Rights Council we know today was established. Since its establishment in 2006, it has adopted, by a considerable margin, more condemnatory resolutions against Israel than against all other nations throughout the entire world put together. So that's completely absurd. The standards being applied here are completely absurd. And within the United Nations, there is a comprehensive, yes, one must say, an extensive infrastructure that has nothing to do with anything other than churning out anti-Israel propaganda every single day. There exist countless UN sub-organizations that are exclusively dedicated to ultimately the defamation and discrediting of Israel, and these are financed with enormous amounts of money. And they do nothing else but consistently put out report after report in which Israel is simply denounced. So a colleague and I actually looked into this several years ago, and for all those who are interested, I can only gladly point you to the book we wrote at that time, United Nations Against Israel, How the UN Delegitimizes the Jewish State. So, with the UN, none of this is unforeseen, so to speak. It's part of a very, very poor tradition of the United Nations in its dealings with Israel since the 60s at the latest. And when it comes to human rights organizations, it's also quite striking, yet again. For some, several of these organizations, especially Amnesty International, this involvement with Israel has taken on such an obsessively deep and pervasive character that one can only truly marvel and wonder what in the world is actually going on. This is what we see. And what's particularly interesting is the stark contrast in how they behave in other situations and cases. So if we were to look, for instance, at the brutal crackdown on the protests that occurred in Iran. For 2 whole weeks, we heard absolutely nothing from Amnesty International Austria. Right? So, the organization that, for the past 2 years during the Gaza war, published post after post at an incredible frequency, constantly accusing Israel of war crimes and putting them on blast, now, after the eruption of protests and the Iranian regime's brutal violence, has remained completely silent for weeks. It didn't utter a single peep about what's unfolding there. Well, what is that, if not a clear case of blatant double standards being applied here? And here too, as for the reasons for this change in course, I can only speculate. I can't truly know what goes on in the minds of the Amnesty folks. However, the undeniable fact remains that their donations have surged dramatically ever since Amnesty wholeheartedly embraced this vehemently anti-Israel stance. And for organizations like Amnesty or Human Rights Watch and so on, fundraising is one of their main activities. And it's obviously a very lucrative business when you target Israel.
That's just speculation again, but isn't there legitimate criticism? These are serious accusations against the UN. However, isn't there also some justified criticism regarding the West Bank, where Israel, at least in certain aspects, does not always act in full compliance with international law as it ought to?
Yes, so the West Bank case is, even from a legal perspective, actually quite an interesting case, because it's not entirely clear what the status of this territory really is. If we recall what occupation truly entails, specifically boots on the ground and a genuinely distinct administration, one must acknowledge that in significant areas of the West Bank, that situation does not currently exist. Because, nevertheless, significant portions of public opinion will still speak of it as an occupation of the West Bank. And Israel, at least, maintains that it adheres to the Geneva Conventions, particularly in that the treatment of Palestinians is governed by legal principles, precisely as it would be in an occupation scenario. In the West Bank, there are certainly incidents that are anything but pleasant occurring, so there are assaults that deserve condemnation. It's truly a shame that the Israeli state doesn't prosecute them as it should, or frequently turns a blind eye in far too many regrettable instances. It also, of course, has something to do with the political circumstances and realities in Israel. There's certainly no question that the state's deliberate inaction, its looking away, or outright failure to intervene, has significantly intensified since this particular coalition, which includes far-right members in crucial ministerial roles, took power in Israel a few years ago. But in detail, you'd really have to grapple with very specific allegations. For instance, there's always the recurring issue of settlement construction. One can debate this endlessly, but even on the topic of settlements, the same question always emerges. There's no other global conflict, no other war, no other occupation anywhere in the world where arguments are made in such a unique way as they are in Israel's case. So there too, it's quite obvious that double standards are unequivocally being applied. So when it's asserted, for instance, with direct reference to the Geneva Conventions, that certain settlements are deemed illegal, one discovers there isn't a singular other global instance where this specific and highly controversially interpreted wording is actively put into practice. Not in Cyprus specifically, not in the Greek part, nor in the Turkish part of northern Cyprus, and certainly not in other conflicts globally. Nowhere else do such accusations gain traction or are even made like they are in the case of the West Bank and Israel. So there too, you're dealing with double standards at the very least.
So there's a double standard in the accusation?
Yeah, so that appears to me to be relatively quite undisputed. Yeah, well, it's disputed, but it seems quite clear to me.
Well, thank you. We've really delved deep into this murder document.
Mena-Watch, der unabhängige Nahost-Think Tank. Besuchen Sie auch unsere Website. Dort finden Sie täglich neue aktuelle Berichte und ausführliche wissenschaftlich fundierte Hintergrundanalysen zur Geschichte und Gegenwart der MENA-Region.